Good evening. This is a meeting of the Athens Board of Zoning Appeals. Time is approximately 7:01, and the date is December 14th, 2010. This time I'll call the meeting to order. The board consists of 5 members and 2 alternates, the alternates taking full part in the discussion of becoming a voting member in the absence of a member when a member abstains for conflict of interest. Present tonight are Michelle Draybold, Betty Hollow, Lisa Carson, alternate, will be acting as member, and Kay Towsley, alternate, acting as member, and myself, Joan Kronansky, acting as chair. Also present are zoning administrator John Paskey and secretary Paul Eschenbacher. And I think that's it. The board operates according to the following procedure. The chair will name and describe the case. The zoning administrator will state the basis of the objection and any applicable facts or conditions pertaining to the case. The appellant or their representative will give reason why the appeal should be viewed favorably. Anyone wishing to speak in favor of the request will be heard. Anyone wishing to speak in general comment will be heard. Anyone wishing to speak in opposition will be heard. If necessary, the appellant or their representative will offer concluding summary or rebuttal remarks. Testimony from the floor shall be closed. The board will deliberate and then render a decision. According to Athens City Code Section 230703B, the board has power to grant variances from the strict application of the code, provided the variance will not be contrary to the public interest, the spirit of the code is observed, public safety and welfare are secured, and substantial justice is done. According to Athens City Code Section 230910C, variances from the code should not be granted unless the board finds, based on direct, specific findings of fact, that each of the following conditions have been supported. Practical difficulty and undue hardship because of the exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property. A literal enforcement of these regulations will result in a practical difficulty or undue hardship that is unnecessary to the achievement of the public purpose. Exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone. Preservation of equal property rights. The literal interpretation of these regulations would deprive the appellant of rights commonly enjoyed by others in the same zone in the same vicinity. While granting a variance of the While a granting of the requested variance will not confer on the applicant any special privileges that is denied to other properties in the same zone in the same vicinity. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property. Absence of detriment. The authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purposes of the zoning code or the public interest. Not of a general nature. The condition or situation of the specific piece of property or the intended use of said property for which variance is sought, one or the other or in combination, is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation for such condition or situation. Any person, resident, or officer, department, or appointed body of the City of Athens, aggrieved by a decision of the board, may petition the Athens County Court of Common Pleas concerning the illegality of the decision. Such petition must be filed within 30 days after the mailing of the decision of the board to the appellant. There are 2 cases on tonight's agenda. The first case, 1011V, and the appellant is Cody Rentals. The second case, case 1012V, and the appellant is Peter A. Costas. The board is required to take testimony under oath. When anyone wishing to speak concerning any item on the agenda, please stand. The board is... Okay, do we have everybody up now?
I'm sorry.
Okay. Are you not going to speak?
Me?
Yeah.
Attorney, I don't normally
formally get sworn in because I'm not offering testimony. I'm just helping to present information. And if you want me to.
Well, anyone that speaks, okay. We know. Okay,
Yeah,
we have to wait
my
here.
other duties.
I know. All right. Do you swear or affirm that any testimony you will present to the board will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. The first case 1011V, Cody Rentals for property located at 62 Stewart Street. The appellant is requesting a variance from Section 230502 to permit renovations to an existing structure in a non-conforming situation, side setbacks of 5.5 feet and 7.5 feet for a total of 13 feet for both sides, where the minimum side setback requirements are 8 feet on one side and a total of 20 feet for both sides. That would add a new roof over the second-story porch. And we have our packets. So I think maybe if Mr. Eschenbacher would like to add anything to the information that we have already.
Just that this current building was built in 2004 on the existing footprint of an older structure that was there. Fast forward to a few months ago, one of the code officers noticed the new roof structure over the second floor front deck and notified the owner that because of current administration policies and stuff, that the building of such a roof required a building permit, which the owner had not gotten yet. So the owner then filled out a building permit for the roof addition, and we refused it based on the fact that the building is a non-conforming building, and a change in a roof line constitutes enough of a change that has to be factored in and considered for the permit. So it was refused on the basis that it is a non-conforming building and a change in a roof line would not normally be allowed. So, and as I said, the only thing to add is that the roof is already built and that the owner had said that the reason for the building of the roof was that they had problems with rain leakage from the deck into that apartment from that deck entrance.
Did you say that the building was rebuilt in 2004 on the existing footprint?
Well, basically the old building was torn down and this was put up on the same footprint.
So it was rebuilt as a non-conforming building?
Yes. Well,
bit unusual.
At that time, the zoning administrator at that time interpreted to mean that if something was built on the exact same footprint, it was not more non-conforming, and therefore it was approved by him.
I see.
So it didn't come before the board. That's what I was wondering, if there was any history of...
No, this is the first request for any kind of variance for this address.
So the roof that we're looking at this structure is the roof that's already in place that we're asking...
Over the front porch, over the second-story front deck, yes.
Okay. I guess I counted up that looked like it was a third story.
Well, upper floor then, upper apartment deck.
Does anyone have any questions?
Not.
For Mr. Eschenbacher? Okay, well, the appellant or their representative like to come to the podium, and you'll have to state your name and your address, please.
Good evening. My name is Todd Grace, and my address for my office is at 19 West Washington. And I am an attorney in town, and Mr. Cody has hired me to come in and present his position on this. I also have one of his employees, Brian, who's present and has personal knowledge and will help to present some information to the board. I did bring some pictures as well. I don't know if everyone was able to see some of the property, but I thought that would be helpful to see exactly what's being discussed. In court, I would have a witness identify what this is and present it, but if it's...
Well, you can just bring it up to
That's what I thought.
to the board, and we're a little informal. I know we made you swear, but...
That's okay.
The shoes
I
on
have-
the other foot. Huh?
This first picture is 62 Stewart, and you can see this building, or this roof, is the roof in question. The porch was already there apparently, and if necessary I'll have Brian explain what was there. And they added the roof line. This is 60 Stewart, has a similar building, has a similar porch, and a similar roof. This is also 60.
Mr. Cody likes that color. These are other buildings.
These are all in Schaefer.
These are all on Stewart. They're
Stewart,
actually
sorry.
labeled on the back to help
Yeah.
explain what it is.
They're all up and
Okay.
down there.
This is a picture of the 68 and 70, and what I was
Oh, with a
explaining-
code violation?
An old picture.
Yeah, I have no idea.
I was the photographer.
So the main issue from those pictures is just to show that, first of all, it is a roof. The roof is the only thing that's being added. The porch was already there. That was part of the plan in 2004 that was submitted. And there is a new roof that was put on. And
Can I
Would
see
you-
that original picture one more time, the first one?
It's quite a stretch. Go up the street and the lots. See.
Okay.
Okay, so the picture shows that, first of all, there is not going to be any change in the square footage or the footprint of this building from adding the roof, and I think that's one of the issues that the board should consider when considering granting it. I think one of the primary objections that code has is the fact that the roof's already been built, and I'd like to let Brian explain what efforts were going on at that point in time, what they were doing to address the water leak, and why they took this step to try to get it corrected, and why he believes that was the minimum means of correcting the water leak and taking care of it.
How is this different from what they planned?
25 West Washington Street in Athens. I live in Athens. The structure was built in '04, I believe, Mr. Eschenbacher had stated. During the year before last, we received a complaint from one of the tenants about water coming into one of her bedroom. And what we did is we tracked the problem down to that porch. There's decking on the porch, and underneath that porch there's a rolled rubber roofing. And when that was put in place, it didn't go up as high. So during a driving rain, water will come through that. And so what we did is we ended up taking all the decking off that porch and redoing that. Well, during subsequent rains, we thought that we had solved the problem, but in harsh weather, driving rains, we would still get that water coming into the room. So my boss, Dr. Cody, thought that a good idea in order to stop that would be to put a roof over that porch, existing porch, in order to further shelter that section of the house.
So this is a new roof, right?
Yes.
Not just a replacement roof, but...
No, there was no roof over that
Okay.
porch. So we constructed one in order to help shelter from the driving rain.
And you've worked for Cody Reynolds for some time, I assume?
I've been employed for about 5 years.
Okay. I'm just a little shocked. This is just a commentary that you didn't get a building permit. Because you...
I was not aware that he
Right.
had not applied for one. That's
Right.
not part of my job.
That's not part of your...
Well, but it should be posted, right, if you were going to do something. So, I
guess.
mean, I would think within 5 years of all the construction that had gone on in that area, that posting would be crucial. I guess a question I'd like to ask is, since the roof went up, has there been any complaints of water?
I haven't received any complaints.
So how long's the roof been up?
I would say the roof has probably been up maybe 3 months.
Interesting solution, because I'm not sure it's going to keep the sideways with their house. That's not my problem.
Right.
It might be a little bit longer than that. It was done late, so.
What do you mean, wider? Or-
It might have been up, it might have existed for 4 months.
Okay, gotcha. Well, you maybe did it for fall quarters rentals or whatever. Okay. Then you haven't had any complaints of water that you know of?
Haven't had any further complaints. And we did have heavy rains this fall, and I have not gotten any subsequent calls.
I'm noticing that there's also an additional railing up above what currently exists. Is that bringing it up to code too, John?
It's ready.
There's a metal railing here to bring it higher.
No, that railing was already existing. The metal. That metal railing
Yes.
was already in existence.
That was already there.
Yes.
It's a new construction, the 2x4s.
Yes.
And then the roof on top of it.
Yes.
Do you want to tell them that?
The new construction consists of the 4 new posts and the roof itself with the peaked roof with the siding. That's the new addition.
A new railing wouldn't be a permittable issue anyways.
Any other questions for Brian?
I don't think, does anyone have any other questions for Brian? No, not at this time.
I have spoken with Mr. Cody about this, and I've addressed the issue that this should have been dealt with as a permit before doing the roof line. When they started, they thought it was a repair, which wouldn't have required a permit to do the repairs to the leaky roof for the part that was just the decking and then doing the roof line underneath it. Or sorry, the tar paper rubber underneath it. It became more than that, and I think they understand that that's something that in the future they have to come here first. And I think that the code would probably deny any request and then have it come to this board, and then the board would need to make a decision on it. And they are apologetic that they did it that way. I don't think they intended to violate the code for that. I think they were just doing a repair that became something that should have gone through this boarding zone of appeals. In his application, he did outline all of the issues that are part of what the zoning board of appeals needs to address as far as covering, is it going to create a danger? Is it going to be outside of the general purposes and intent of the code? I think he actually did a very good job with his narrative of outlining justification for it, and he believes that this would be the minimal to allow reasonable use of the building to keep the water from coming through, does not impair supply of air or light to adjacent properties, does not substantially increase congestion in public streets, does not increase the risk of fire, does not endanger public safety or substantially diminish or impair adjacent property values, does not, granting the variance would not confer special privilege on the appellant as evidenced by the other pictures of properties that are adjacent to it. At this point in time, I would ask the board grant the variance. It probably should have been dealt with a little bit differently, and they recognize that, and I don't think that'll be an issue again in the future. But the short version of it is, this is a good thing. They put a roof on that porch that was there, they didn't increase the footprint, and they've corrected the water infiltration issue. Thank you.
Thank you.
Thank you.
Well, I see we have a nice audience over here. I'm assuming no one wants to speak of general nature. And is there anyone that wishes to speak in opposition? I guess those would all be no's.
Don't have any letters.
Would the appellant have anything to say before the board closes the discussion?
I do not. Thank you for your time.
Okay. Okay, well, I guess board's going to close the discussion, and we'll put a motion and call for a vote. Someone like to put a motion up? Michelle, are you?
Oh, you want me to
Sure.
grant a motion? Okay. Yes, it's right here. I move that case number 1011V, that we grant a variance from section 23.05.02 to permit renovations to an existing structure in a non-conforming situation, side setbacks of 5.5 feet and 7.5 feet, for a total of 13 feet for both sides, where the minimum side setback requirements are 8 feet on one side and a total of 20 feet for both sides. That would add a new roof over the second-story porch.
I would suggest that we add a condition that it not ever be allowed to be enclosed, because once you have a roof over something,
I totally agree.
You would,
Well, if they would decide to enclose it, they would have to get another permit.
perhaps.
Well, no, they'd have to get another permit, because that would definitely
But
be
it won't hurt to have
adding
that as a
square
condition.
footage.
Yeah, it won't hurt to put it in as a condition, will it?
Yeah.
Okay. So can we...
But you want the condition that it cannot be enclosed?
Yes, because presumably with the porch, it could be,
Yeah, that roof is
potentially.
A substantial roof.
structure, yes, as opposed to just a tin roof, that would have been sufficient. Okay, does someone want a second?
My second.
Okay, have a second, I guess. Any more discussion on the issue? I guess we'll call for a vote. Michelle,
Well, you got to go through.
We got to go through the findings.
do we have to? Okay,
We always forget something.
yes. Okay, let's read through the findings, and first one being practical difficulty and undue hardship because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property. A literal enforcement of the regulations would result in practical difficulty or undue hardship that is unnecessary to the achievement of public purpose.
It's debatable.
Well, I think we're not necessarily talking so much about the porch as the fact that the property is non-conforming.
In the first
And
place.
that's what brings it into play. And I guess that probably all of those properties that we just looked at in their pictures are also non-conforming. And since the board was generous enough to allow Cody Rentals to rebuild the property exactly as it was, which was non-conforming, rather than letting the non-conformity disappear by making it smaller or not building at all, then I think we have to say that there is an exceptional circumstance in terms of the size of the lot and the permission that was already given to it to rebuild as a non-conforming building.
Exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question or to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone.
I think Betty described it well.
Right.
Well, except now you're looking for an exceptional circumstance that does not apply to the rest of the properties.
And which is not the case. The exceptional circumstances apply to most of the properties.
Well, I guess you would say they
We
had
have
a bad contractor, and so the rain comes in.
Correct.
Although that's not a very good circumstance.
I think, right, because if you create the circumstances yourself, then the hardship, then that's,
Well,
but it is still an issue, and it needed dealt
yeah,
with.
typically we do treat these sort of together, so, okay.
Preservation of equal property rights. Literal interpretation of these regulations would deprive the appellant of rights commonly enjoyed by others in the same zone, the same vicinity, while the granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties in the same zone, in the same vicinity. Obviously, from the
properties.
pictures, other properties have porch roofs
Yes.
on the
I think
second or
so.
upper stories, so
Well, and it's very likely that, well, maybe he would have had to come here anyway, but, I don't know. If they built a building with that porch, I don't think anybody would have been too upset, so it's not a big issue.
Right. Minimum variance, the variance granted is a minimum variance required to make possible the reasonable use of the property. In terms of the water lake, I guess it is the most minimal variance that could be granted.
There might be other solutions, of course, but
Well, that may mean taking down the building and rebuilding it.
well, maybe they should just replace the sliding glass doors.
Well, that's not where it was leaking, right, it was going under, right, but, well, there could be right, but, okay, we'll pass on the minimum variance. Absence of detriment, the authorizing of such variance will not be of substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest. At this point, I
Not
don't
at this
think
point.
there's
It's already been
substantial
done.
detriment to adjacent property.
Everything's been done.
Right. Not of a general nature, the condition or situation of a specific piece of property or the intended use of such property for which variance is sought, one or the other, or in combination, is not of so general or recurrent a nature as to make reasonably practicable the formulation of a general regulation for such conditions or situations. And I would say no. Okay, so now we can call for a vote.
Yes.
Michelle?
Yes.
I vote yes.
Betty, yes. Lisa?
Yes.
Kay?
Yes.
I vote yes. Motion passes 5-0. Thank you. Okay, we're going to move to our second case, case 1012V, for West Stimson Avenue, located in the Zone B3. And the appellant is requesting a variance from Section 230313I3 to allow placement of a permanent freestanding sign 3 feet from the side property line, where the minimum requirement is 10 feet from the side property line. We have various things in our packet, and Paul, before I call on you, I guess I have a question. I'm assuming that this sign that we're discussing is the freestanding? Okay. Paul, would you like to add anything to the information that we already have?
Just that the bicycle shop, which used to be in that small shopping center, just a few dozen feet away from this current property, and they moved into this, one of the former old brick houses there along that small section of West Stimson, and they've renovated it and just want to have a sign out front, and they believe that placing the sign where it would be required in front of the building would be either detrimental or certainly difficult for them. They could probably describe it in better detail than I. But that's the only problem we had with the sign permit application, was its location in terms of the side property line. Everything else was okay.
They did a huge remodeling job, and they had conversations with the city over the city right-of-way, and that was all discussed in our packets.
That was a Title 41 project. They went through the entire process with the city. So,
I remember several years ago being on a committee, ad hoc committee, with members of the Chamber of Commerce and community people and code people, and there was a particular check sheet that people that do major construction go through various processes, and there were timelines so they could see everything they needed to do in order to meet all the city, and if there were county and state federal regulations, and all the permits that were necessary. I'm assuming that still exists and that the option of sign was on that checklist,
we
right?
don't use the checklist per se anymore. I mean, we'll give them a guideline of what they have to do, but it's kind of a, on the Title 41 application, there is a box on there that kind of indicates the different departments that it's reviewed by internally with the city, and it does go to the Planning Commission and it's voted on. And signage is one of the issues that is on there. that doesn't need to be submitted at that time, but we just let them know if and when they're ready to come and do the signage, that it would be a separate permit at a separate time, which it would be anyways. So, and then they got the building under construction and underway and nearly done. Or are you in?
We have our occupancy permit.
Okay, they're done, and then they submitted for the sign permit to take the old sign down from their old building and move over to here.
So the city's been aware all along that the sign was going to be in violation?
No. We knew he had to submit for a sign permit, didn't know where he was going to do it, or when he was going to do it. We just knew when he was ready to put a sign up that he would have to submit for a permit.
But Mr. Paskey, I mean, there's no place to put a sign. The porch, I mean,
Right, this is my, self-inflicted situation here that I know was, I don't have any objection to the business and the location, but, when you look at all things and you weigh them out here.
Well, no, because there are options. He could have put it on the front of the building.
Right.
He could have put it over on the other side of the building. He could have put it on the building. I mean, there was a bunch of different options. His request is to put it at this location, which, we denied because of the distance from the side yard. So at the time we ran everything through the Title 41 process, we just told him he had to eventually submit for a sign application because there were 3 or 4 different options that he could have come through that would have, not needed this approval. So.
Well, one of the comments that the appellant makes in his statement is that it could go on the roof, but he doesn't want to do that. Can he put it on the roof?
Well, not on the roof. I'm saying on
like
the gable.
on the
front of
gable
building.
where the porch
Yeah.
or the walk-in area, above the door, front door or whatever. Okay.
Yeah,
So that would not be, I didn't see anything in the code that said that was a violation, but
he could have put it there, not on the roof. I mean, I can't tell you without researching it, but that wasn't what I meant by on the roof. I meant on the front gable of the roof.
does anyone else have any questions for Mr. Paskey or Mr. Eschenbacher? Then if the appellant or the appellant's representative would like to step to the podium and state your name and your address, please.
Hello, my name is Peter Katsas. I reside at 1 Bryan Road, and the property in discussion tonight is at 4 West Stimson Avenue.
Would you like to say anything else in support of your variance request?
Basically, we wanted to retain the front look of the building, and so we really didn't want to muddy it up with a pole sitting right in front of the building. Also, if you measure from the setback that you need from the center line of the street, it's 18 feet from the center of the street to the curb. Then it's an additional 10 feet before you hit my front stoop. So roughly in front of the building, we have 3 feet, give or take. Probably we might be more about 2.5 feet when you think about how far you want to be back away from the building. So when we did move, we found that a lot of people recognized our sign as being a good locator, and this is of course is the first spot that we would have liked to put it, and this is the only place that, even though it infringes on the neighboring property, that I did contact Pete Good, who's the owner of 6 West Stimson, and he signed off on it, saying it's not, to him, it's not an issue. This is where we would like to place the sign. The rest of the front of that property, because the building is so close and there's the right-of-way, and then that we constructed a sidewalk for access to the back of the building for our customers. There's no other spot that we could really stick with that same signage on the property.
So, Mr. Costas, just so I have this in my brain, the pole will sit where with the sign?
With the sign?
Just tell me, you've got the front of your property here. Where are you locating it?
It would be you mean if you were looking directly across the street, standing on the opposite side, on the post office side?
Okay.
Looking at the building, it would be to the left
Okay.
of the building,
Okay.
about,
West side of the building.
Right, and this is where you're saying 6 Stimson?
yes.
He owns that property, so it would actually sit in his,
His side, his property. where
On the
the
side of his
lawn
property.
Yes.
Would be close to that.
there's a couple properties in between Mr. Good and,
This is just showing you that there's another property
no,
on the
I know
street.
that, no,
Okay, so
I know where I'm
we
at, I
okay.
totally know where I'm at, but
Okay.
where's that map? Of the,
Let's see, maybe that picture that
Towards the rear.
Let's see, here it is.
there it is, okay. Okay. So it would sit here, and then there's those 2 other little company houses. There's
Correct.
2 of them before you get to the Goods property.
Pete owns
Pete owns those 2
No, he
properties.
owns the one.
He owns
And then
the
the
one.
one that's in between the rental he owns and then the laundromat is still a residence.
Okay. So it would kind of be in the rentals front setback or yard or whatever.
It would be 3 feet off of his property line.
Instead of 10.
And it would be almost with the width of our sign, it would probably be it would be sitting back behind the front porch, maybe about a foot, that...
Your
that-
front porch?
Correct.
Yeah,
yes.
because
Mhm.
yours is out.
That
Yeah.
gable end, yes.
Okay.
So you're putting the pole in the ground 3 feet from the property line?
Yes. Mhm.
So then the sign itself is fairly wide, so the sign itself would be maybe a foot, if not less, from the property line?
The sign itself is actually it's a metal sculpture. It's a bike rack. It's probably only about 6 inches wide. In fact, I think that the pole itself, the size of the pole that we would put up, would be roughly about the same size as the width of that sign.
So you're not moving the sign, the original sign?
No, it is the original sign, but it was Pete Good's pole that it was sitting on, so we took it off the pole.
The bike would be running parallel with the property line, not close.
Yes.
Perpendicular to the street and the sidewalk.
But then the sign, would you have the sign Athens Bicycle below it?
No, that was
So it would
that was
just
a
be Athens
13-year-old mistake.
Bicycle. It would be Athens Bicycle here at the top.
Correct.
Would be the identifier for your
Yes.
patrons.
Yes,
And you would see it coming east or west on Stimson, is that correct?
correct,
Not head-on?
correct.
So this, way up high, this would be kind of hanging over the sidewalk? No?
No, it would, no,
It'd be back farther.
we would want the front end of that to still be back behind the 25-foot right-of-way. So the pole itself would not be sitting
Right.
directly at 25 feet. It would probably be more about 28 feet.
All right.
I think it would be really good to see exactly the dimensions of all of that. I mean, I don't have an objection to all of this, right? But every time I look at that space and I think of
They're small.
how small it is, and it's one thing to talk about it, it's one thing to appreciate the sign, it's one thing to appreciate the work that you've done, but, when you get into real visualization of some of these things that come through here, you go, oh, I approve that, because you have not really had a true visual of it. And that is such close quarters, and I know that Mr. Good has no objection to it, but, he could move on, somebody else can move in there, and it's not about Mr. Good or you, it's about how the city envisions signage, and so I'm really torn with this because of that very reason.
You've done wonderful things with the property. I mean, it looks, and...
Yeah, and this is, this purely is an aesthetic,
And the sign is
approach.
interesting and different, all those kinds of things.
So is this the size of an ordinary bicycle?
It
It's a
is,
sculpture, so it's not
No, it's roughly, it's close. It's pretty
Okay,
cloose.
so
I think it's
about
pretty close. You looked
Yeah,
at it.
yeah, good, if you,
maybe
yeah.
a little skinnier in terms of its width this way?
The width of the tubing itself, do you mean? Or
Yeah.
The tubing itself is probably about 1.5 inches. And so it's,
Well, from my perspective, I understand what Ms. Kronowski is saying, but there is so much open space to me that I don't see it as an overwhelming sort of sign, because it's not white space.
not like a
It's
billboard.
transparent space.
I realize
it's
that, but
not-
you're not living 3 feet away from it. That's my issue.
Well, I understand that, but the owner of that property has said that he does not object to it. And there is another property on the street that, for no reason whatsoever, has its sign equally close to...
You're talking about goods? Well, I wonder how long that's been there.
No, I'm talking about
Ambassador.
Ambassador Laundry. It's probably
Okay.
been there a long time,
Right, and
nevertheless.
so that's already,
Nevertheless, it is there, and it is in the same neighborhood. So there is some question then whether you would be denying Mr. Katz's
Well,
a
here's
right that somebody
Bellavino.
else on the
That's
property
kind
also
of
has.
right there, right on
Right.
the edge.
Right. Yeah, those little properties.
Because
used
here
to
he
be
is,
little
right down
company
here.
houses, So the lots are quite tiny.
Here's where it goes, where the sign goes. Okay.
but in our, we're talking about the residential place.
It's a business
It's
district. It's
B1.
not a residential
I mean, B2,
district. It's a
B3.
B3. So
Right.
the fact that there's a rental there is incidental, I think, to the zone, because those little houses were company houses. They probably were residences.
Yes, I know
primarily a
exactly
long
what they
time
were.
ago. Right.
I know exactly what they
And
were.
do you also own the one next door on the corner? Because I know you've put parking in the back and all that.
Yeah, 2
And
west.
is that a rental as well, or another business? Or
It currently is,
maybe
we-
another business later?
I hope.
You hope?
I would like to see that street shift back.
Yeah,
Right, and I think in the...
in the grand scheme plan.
The plan that they came up with a couple of years ago, the section of Stimson was intended to be a neighborhood commercial area. So, yes, so everything that's there is fine. I just having difficulty with, because there are options. And I know what you're saying about the sign. The sign's going to be this way, and some people are going to miss that because the very fact, on the one hand, as Ms. Hollow mentions, you can see through it, but you can see through it and you can just see right through it.
Well, but you see, it's a bicycle.
Putting it on the front of the building,
Would make it invisible, because when you're traveling, if you're walking down the street or if you're driving down the street, your line of sight is this way, and the sign is this way, so you'd see the sign.
Well, it's still gonna be back
If it's
far
on
enough.
the top of, it's on the front of the building, you would
Right.
only see that if you were on the opposite side of the street walking.
well, I've been through some small communities, Mason, let's say Mason, for example, and they have a lot of businesses, and occasionally you see a little house, but mostly in their little business district that they've rescaped. Businesses are close together. People have their signs in the front of the building. And so it depends on what kind of cultural signage we want to do. You look in here and you go to some of these meetings and people are talking about low invasion of signs into the area. And so I think it's possible that putting it on the front of the building might be a good way to, I'm sure there's some way you could, with a little bit of artistic expression, make that bicycle on the front of the building stand out from the rest of the building. And so that is a possibility, and at that point you wouldn't necessarily lose vision.
I do have did you consider at the corner of, since you do own the property next door, did you consider at the corner of Stimson and, is that Cornwell?
Yes, it is.
Yes.
That's a separate parcel, so I don't know that would be
And on-site
considered.
business sign.
So
Yeah,
it
you
can't
can.
do that?
Well, in a B3 you can, but there are areas of the code that specify you can't, and it does say Stimson from Richland to the 33 bypass, but it says the area of, so that's kind of up for question
Kind of vague.
myself right now, as I'm looking into that for something else, and it's a good question, whether it could
I'm
be there. What I'd like to add, though, is it could go the other side of the building, or even in front of the building. and still be in the orientation that he wishes to do so, and he would not have to put it on front of the building. So the sign can be there per code the way he wants it other places. He's just wishing to move it a little closer to the property line. So we can't say just put it on front, you know. I mean, he does
So
have
there are
options.
other options.
Absolutely.
This is just a personal preference
Yes.
for...
Yeah.
We've spent a lot of time on the front of that property, and that's kind of where we feel that it would be it wouldn't be obtrusive. We're not looking to stick LED lights on it. We don't want to light it. We just want something that during business hours people can look up and they're like, oh, that's where I need to go. I mean, currently, right now, I didn't put there was a lot of other things I needed to think about. This was a pretty big project, and the signage wasn't at the top of my thought. As you can see, that's why I'm here. But really, now that I've been in there and we've been operating now for close to a month without a sign, I've had deliveries. I've had semi trucks that can't find me, and they've circled around and gone up and down the street a couple times. And I've had people come in and say, "We just can't find you." And we got a banner. We got a temporary permit. We got a banner. We have it running parallel with the street, but it's not enough for people to recognize that we're there, even though we have bikes in the windows and we've done all this work over the course of the summer.
Well, it still looks like it's in construction too, and I think that's part of it, right?
I don't know. I second guess everything that I'm thinking about
So
right
is
now.
parking for the business on that other property?
Yeah, you access it off of Cornwall.
Off of Cornwall.
Okay. So, I don't know, logically, I'm also kind of thinking that is not a bad a place for a sign, if
Behind
it's
the building?
permittable. No, on this corner.
On another property?
Well, he
You
owns
still
the
have to come
property.
back to...
You still have to go back here to park and to enter into the building unless you're on foot, correct? Or you come around the side and then come in the front? Is that how you enter from the parking lot?
But there's a door on the side of the building
So you can enter right in from where you
from
enter
where you're
from?
parking is.
If he
Yes.
ever did turn that other building into a commercial business, it could create a problem too, with two signs on the same lot or the size of the sign on that lot, so.
Okay.
But you are saying there is room in the front of the building, considering the setbacks. I mean,
The
that's
sign
real.
and the B3 can go on the property. So as he,
Right.
like Peter was saying, that
On zero
the
property.
what's the right of way there? What we come,
It's a 25-foot setback.
25 foot from center of the road. So
Right.
when his building's back, so there's like 3 or 4 foot between, or 2.5 to 3 feet between the front porch of his building and the property line. So technically, it could go there. It could go over on the driveway side to the right of the building as you look at it, and it would still be within code. And he can bring it all the way out, even on the left-hand side. He can bring it out to the property line, and he's wishing to hold it back from the property line, just meaning the front property line. Just he's wanting to move it closer to the left property line. So, but he could put it, like I said, up on the property line, 10 feet away. It would be kind of probably about halfway between the edge of the building and his front steps, maybe somewhere in there in front of the building. And his desire is to hold it back a little bit farther off of the front property line. But because of the width of the building and because of the narrowness of the lot, he doesn't have the 10 foot on the left-hand side. So that's the reason for the request. So to put it on the left side. The right side,
In the front of
That's
the
his
building,
option.
if you put it in the front of the building, how far back from the sidewalk would it be? It's practical.
If, assuming, I don't know if we
Does
measure.
anybody have any idea?
It would have to sit 3 feet, 3 feet back from the,
It would be 3 feet back from the physical sidewalk
yeah.
that's there.
That would be the pole or the end of the sign?
That would be the end of the sign. That would be 25 feet. Because if you combine the sidewalk and and half of the street width, you're already at 22 feet, and you have to have a 25-foot setback.
And your reason, again, for not wanting to do that is
You mean for...
more in front of your building or rather than on the side?
Well, 2 reasons. One, the sign that we've used for 7 or 8 years wouldn't fit because it's at least 4 feet. wide. The second one it's aesthetic. I just don't want to have a big pole
In the front of the
chunked
window.
right down in front of that porch that we built.
Right.
So, and then at that point, do we move it over and take the sign higher so that the sign sits above the porch, or do you lower it down so that it sits in between that gable? To me, it just doesn't fit. So, and even if we decided to change the sign and went to a skinnier sign, it still looked like you're stuffing it in there. It just doesn't.
Okay.
Anybody got any more questions?
Well,
Do we
yes,
need
so that's
Mr.
why I'm
Cox's
waiting here
anymore?
for a second. I wanted to, so, when the sign was located in front of the small plaza, it was parallel to the road, right? And now you're switching it so
No,
it
it
goes
was
in the other direction.
it was perpendicular to
It
the
was
road. It was perpendicular, yes.
Okay.
Yeah.
Well, he wants to put it right here, and that's all.
And have you seen this? Have you looked at this? So you know this is where he wants to put it, right here.
I looked at the whole back.
Okay. Everybody knows, right?
Right. Oh, you're talking about the corner?
Yeah, right.
Well,
That's where he
whereas
wants,
if you-
this is what he's
If you
asking
put
for.
it here, it would be right in front of the porch.
Right, right.
If you put it here, he's suggesting that it would make it difficult for people who are
To get around.
in wheelchairs or on crutches to make easy use of the sidewalk. And beside, maybe it would be sort of behind the porch. Anyway,
All right.
The other thing is that about that section, and I don't know how much of an issue this is, but all the utilities, the gas and the water all runs in right at the right-hand side there. So I don't...
There may not be a place to put the pole because of all those utility
Correct.
to
Yes.
sink the pole.
Well, I really didn't think from your statement that facing the house on the right-hand side where the sidewalk is and the city right-of-way and utilities would be a practical option at all in terms of logistics. But anywhere else was, I figured, fair game. But yeah, no, that side is not. Does anyone else have any more questions? No questions? Okay. Unless you want to add something?
No, I'm done.
Okay.
Great, thank you.
Thank you. Would anyone like to comment of a general nature regarding the variance? Would anyone like to speak in opposition to the variance? Unless you have any more comments to make, we'll close the floor.
No, I don't, thank you.
Okay. Somebody want to make a motion?
Yes, I move that the board consider granting a variance in case 1012D, Zone B3, for West Stimson Avenue, Peter Kotsis appellant, from Section 230313I3, to allow placement of a permanent freestanding sign 3 feet from the side property line, where the minimum requirement is 10 feet from the side property line.
Second.
Wait a second, wait a second. Okay, let me read the conditions we have to consider. Practical difficulty and undue hardship because of exceptional or extraordinary circumstances or conditions pertaining to a specific piece of property. A literal enforcement of these regulations will result in practical difficulty or undue hardship that is unnecessary to the achievement of public purpose. Well, the size of the property makes it difficult to, under some circumstances, especially where he wants to place the sign, make it a hardship, although there are other locations on the property that I think the sign could be placed.
that's possible, but it's frequently true that people could do something else. For example, Mr. Cody could have done something besides putting up a roof. He probably could have gotten the contractor back and worked on the rubber stuff some more. So I
But he already
suggest...
did have the structure up, and he did have the porch up.
That's irrelevant. He shouldn't have had So...
The roof, no, I didn't say the roof. The roof, he should never have done that, right?
Okay.
That is correct. But I think
This is asking for a variance. And I think that there is. Although, you're right, he could put it across the front of the building or in a slightly different place. But aesthetically, he's interested in having it in a place where it's attractive and practical.
exceptional circumstances. There are exceptional or extraordinary circumstances or conditions applying to the property in question as to the intended use of the property that do not apply generally to other properties or classes or uses in the same zone.
Well, yes, the narrowness of the lot size makes it hard to conform by placing
Well,
the
there are
sign.
other properties, for example, the two on either side of him are exactly the same, but there are other properties that do have larger lots, so it's not that this is, one among many. It's one among several that has such a tiny lot. So I do think it's exceptional. And the building is extraordinarily close to the sidewalk and the street, and to the buildings beside it. So I think there's some exceptional circumstances.
Well, the other thing that, something I was looking at, the code under sign regulations, provisions to control various signs to provide reasonable yet appropriate conditions for identifying establishment in businesses and manufacturing zones, which is what this is. I think there are other ways to go about doing this. I'm not trying to be hard and strict, but sometimes I think that people go forward and do things and self-create some of their own problems because when they buy property they don't think about all these things, and I don't know whether that's something that the code should bring more to light under these circumstances or not, but it's difficult for me to see putting a sign 3 feet from the edge of the property line. We've done 5 feet before out on Richland Avenue, but there was a large number of footage from that property line to the actual physical structure on the adjacent property. In this case, that is not the case, and that's one of my concerns.
Sure, but we have given variances to a lot of properties in town for a variety of reasons. We gave Holza Clinic the right to have 2 signs and 2 entrances, which is certainly against the code, but we said for various reasons, some of them aesthetic, some of them practical, that would be okay. So I think we'll see how this comes out when we vote. So...
Well, I was here for the very meeting, and I actually stood up as a citizen and opposed that because I think that we have to be careful what we do with signage.
As I say, when we vote, we'll see what
But
happens.
the discussion is to bring forward the vote, so if you want to cut it off.
I got it.
Okay, preservation of equal property rights. Literal interpretation of these regulations would deprive the appellant of rights commonly entitled by others in the same zone, the same vicinity, while a granting of the requested variance will not confer on the applicant any special privilege that is denied to other properties in the same zone and the same vicinity. Comment, Betty?
Well, we know that there is one property for sure that has, for a long time, had this right, so you
Right,
can't
which
say-
was in compliance of the code at the time, but code has
Perhaps there
changed.
was no code. There probably-
Or lack thereof,
no one
right.
has asked him to move the sign,
No.
so
Well,
it could
no.
easily be moved, but the city has not asked him to move it. It's still there.
Well, generally because that is a practice that is not done in this town.
Well, that's not true.
Oh.
It's certainly not true.
Okay, well,
People
okay,
sometimes...
somebody cut us off here.
Okay.
Oh, go on. I think we could go on forever. Minimum variance. The variance granted is the minimum variance required to make possible the reasonable use of the property, and I would say
You'd say no, and I'd say yes, so-
Okay, would anyone else like to comment on this? Because I think it's important. No comment. Okay. Absence of absence of detriment. The authorizing of such variance will not be a substantial detriment to adjacent property and will not materially impair the purpose of the zoning code or the public interest.
It's,
Some of the public don't.
well, from my perspective, he's not asking for a sign that is bigger than is allowed. He's not asking for a sign that is taller than allowed. And certainly people do that, and certainly we have granted plenty of those variances.
But we can't base everything on everything we've done in the past.
It's a modest sign
Right.
from my perspective. So, as you know,
Yeah,
I'm going to vote
I thought
yes.
you modest. I think it's
Architecturally cool.
It's a very modest sign. It's a very modest sign.
It's like
No lights, no,
No neon?
no neon.
Look at all the churches we've given.
Oh, don't
already
bring that up.
signs that are lighted, and they're huge, and
I
they're
voted
ugly.
against those too. So I just have to,
Okay, yeah.
I'm trying to
I'll say
pull in
yes, you
some
say no, that's
idea.
fine.
Okay, but I think that a substantial detriment to adjacent property, even though the current property owner of the adjacent property is saying that he is not in disagreement, that I'm thinking of the specific, it's not the individuals we're talking about here, it's the fact that it sits so close to the property line that is the detriment to the adjacent property, and that structure on that property is very close to the property line. So not of a general nature, the condition or situation of the specific piece of property or the intended use of said property for which variance is sought, one or the other, or in combination, is not of so general recurrent in nature as to make reasonably practical the formulation of a general regulation for such condition or situation.
No, it's not of a general nature. We don't have to go to the city council and ask them to change the law.
Okay.
That's not an issue.
Okay, we'll start keeping track of these. Well, if we have to think about this in terms of, as Stimson Avenue begins to develop more small businesses, which it should, this should be dealt with. Okay, so I guess we're going to call for a vote. We'll start down at this end. Kay?
I vote yes.
Lisa? Michelle?
What's
Yes.
Lisa's vote?
Yes,
Yes.
2 yeses.
Okay.
Michelle?
Yes.
Yes.
No. The vote is 4-1, so you have your variance. And I think that should be the end of the case business, and we have the minutes from September 14th meeting, and we were all here, so we can all vote. Does somebody want to move to approve the minutes?
I move that the minutes be approved.
Second?
A second?
Okay.
Okay. Yeas have it.
I would like to add one thing. In our October meeting, we talked about rental signage and going to the Planning Commission, and I don't know, just to have it on record, with Mr. Pasty here, there was an ad hoc group formed with landowners and neighborhood people and city officials present, and we are working through some compromises and coming up with a proposal that will then be presented to the Planning Commission, who will then choose what to do with it and then forward it on to City Council. I don't know if I made that clear. Rental signage.
Rental, property management, however we want to look
Yeah,
at it. So.
however we want to
Yeah.
discuss that.
Well, I'm glad you're doing it, because there was some kind of decision a long time ago, and then sort of crept away and
Yes.
disappeared, so that's good.
So we're
So-
hammering it out.
If there's any other no other business, then we'll adjourn the meeting at 8:05. Thank you.
Excellent.
Thank you.
Okay.